One of the topics that we have covered most on this program ever since it launched is the growing means and prongs of censorship that Western governments and the United States government as well have been creating and employing with the primary intention of controlling and constraining the flow of information over the internet, and particularly big tech platforms where more and more Americans than ever before and more Westerners than ever before are getting their sources of information, so that if you can control that and commandeer it, and if the government can dictate to big tech companies what they should and should not allow on those platforms, that gives them an extraordinary power. In fact, it's the exact opposite of the power the internet was supposed to promise, the ability for citizens to be free to access information more easily than ever. If the government is allowed to dictate and coerce companies to ban dissent and only allow government-approved narratives, which is what we're getting closer and closer to all the time, the internet goes from an unprecedented tool of liberation to an unprecedented tool of coercion and control. And one of the most disturbing features of this new censorship regime, a formal censorship regime, is the way in which the Biden administration created a system for just picking up the phone and calling the top levels of Facebook and Google and X and TikTok and instructing them what they want censored, and implicitly and sometimes explicitly threatening them with punishments if they fail to comply. We've been covering that for years. The Twitter files broke open a whole new way of looking at this. And as a result, the plaintiffs, various American citizens who, including major scientists and doctors at the leading institutions who had a dissident view on COVID, or people who were concerned about the efficacy or safety of the vaccine, who expressed different views on masks and school shutdowns, or who had different views on the 2020 election and its integrity, or who dissented on the war in Ukraine, have been systematically censored on the internet over many years. And it turns out that in many cases, that's because the government at the highest levels was directing those big tech platforms to censor. And the power of the US government is so great that it is almost impossible to resist it. Because when the government picks up the phone and comes knocking through the FBI or the CDC or the CIA or the National Institute of Health and says, these posts are wrong and we believe that they should be taken down, and harasses and badgers the big tech company until they do it, obviously that becomes a form of government censorship. And that is what four federal courts who have looked at this issue, four federal judges rather, who have looked at this issue when a lawsuit was brought against the Biden administration, claiming violations of the First Amendment free speech right, plaintiffs who were censored in exactly the ways I just described, who claimed that their government was abridging the First Amendment right of free speech. A district court judge found in favor of the plaintiffs, wrote a very lengthy and aggressive opinion denouncing what the Biden administration was doing as a direct assault on free speech. And the government, the Biden administration, lost and then appealed it to the Fifth Circuit, where a three-judge panel unanimously affirmed most of what the district court had ruled, also found not only that it was a violation of the First Amendment, but one of the gravest in the history of the court, and as a result, approved of the injunction that the district court had imposed on the Biden administration to prevent it from picking up the phone and calling big tech. But when the Supreme Court decided that it would take this case and review this question, it froze the injunction pending the Supreme Court's ruling. And back in March, the Supreme Court held oral argument between the lawyers for the plaintiffs and the lawyers for the government. And we reported on what happened at the oral argument. We played some excerpts of it. And it seemed very clear that a majority of the court seemed inclined to toss this lawsuit out, not by ruling that what the Biden administration did was constitutional or legal or appropriate, but instead by just simply finding a way to refuse to rule on the question at all, by embracing some more technical or legalistic reason as to why that case should never have been in court in the first place. And that's exactly what the Supreme Court this week did in a 6-3 ruling, a majority ruling written by Amy Coney Barrett, and that was joined by Justice Roberts and Justice Kavanaugh. So those were the three conservative judges, Roberts, Amy Coney Barrett, and Kavanaugh, joined by Kagan, Sotomayor, and Jackson, that formed the 6-member majority. And Amy Coney Barrett wrote the opinion of the court that all the 6 judges signed on to. The 3 judges who dissented were Alito, Thomas, and Gorsuch. Alito wrote the dissenting opinion, but the majority of the court decided to reverse the lower court rulings against the Biden administration, to throw the case out completely, not because they ruled that the Biden administration's actions were constitutional, but simply said, in essence, these plaintiffs have no standing to bring this suit because they cannot prove definitively that the reason they ended up being censored online was because the government pressured big tech companies to do so. Even if they said you can prove that the government pressured big tech companies to censor the exact kind of speech these plaintiffs were expressing. And you can prove that, and they did prove that, because, said the court, you can't prove a direct link between the government action and the censorship, hypothesizing that perhaps it was just the big tech companies on their own deciding to censor. They couldn't prove that it was the government that did anything against them, and therefore they have no standing to ask the court to rule on its constitutionality. This is a common way the Supreme Court evades having to rule on government conduct that they don't actually want to nullify. They did it all the time through the War on Terror, as we'll show you, when people wanted to contest the constitutionality of how the government was spying on American citizens without warrants. The court would say, oh, well, it's a secret who the government is spying on. We can't force them to give us their list because that would jeopardize national security. And because it's all done in secret, the plaintiffs can't prove for sure that they were targets of warrantless surveillance, and therefore their lawsuit alleging a violation of the Fourth Amendment has to be thrown out, not because we think the government's spying is constitutional, but because these plaintiffs can't prove for sure that they were victims of that government action. And I'll explain a little bit more about how that works and what that doctrine is, and actually why it's an important doctrine, despite the fact that it's often abused by courts to avoid ruling, as it was abused here. But before getting to that, let me just show you what the majority opinion began by acknowledging before getting to its ruling. This is what Amy Coney Barrett wrote in the majority opinion. Quote, during the 2020 election season, yeah, we can just show the title first. There you see the title, Supreme Court of the United States. It's titled Murphy versus Missouri, because it was originally brought by the Attorney General of Missouri and Louisiana against a variety of different Biden officials, including Murphy, who was the Surgeon General at the time, who was very active in pressuring big tech companies to censor dissent on COVID. And here's what the majority ruling acknowledged. Quote, during the 2020 election season and the COVID-19 pandemic, social media platforms frequently removed, demoted, or fact-checked posts containing allegedly false or misleading information. At the same time, federal officials, concerned about the spread of, quote, misinformation on social media, communicated extensively with the platforms about their content moderation efforts. The plaintiffs, 2 states and 5 social media users, sued dozens of executive branch officials and agencies, alleging that they pressured the platforms to suppress protected speech in violation of the First Amendment. The Fifth Circuit agreed, concluding that the officials' communications rendered them responsible for the private platform's moderation decision. It then affirmed a sweeping preliminary injunction. And then the Supreme Court goes on to say, quote, the Fifth Circuit was wrong to do so. To establish standing, the plaintiffs must demonstrate a substantial risk that in the near future, they will suffer an injury that is traceable to a government defendant and redressable by the injunction they seek. Because no plaintiff has carried that burden, none has standing to seek a preliminary injunction. In other words, even if you can prove that in the past you were subject to government censorship, then you can seek other remedies. But what the plaintiffs were seeking here, and what the court issued, was an injunction barring the government in the future from continuing to coerce big tech companies to censor. And because these plaintiffs couldn't prove that in the future they will be victimized by the government and its actions, they have no right to seek a injunction governing the actions in the future. Now, that might all sound very technical and annoying and frustrating, but it is actually an important limitation on the power of the judicial branch to only adjudicate cases, not just that raise abstract issues. You can't just say, I don't like what the government's doing here, I'm a citizen, and I'm going to sue and ask the court to rule on the constitutionality. The only time they're allowed to rule on anything is when there's an actual conflict between the plaintiffs and defendants, when there's an actual relationship between the two where harm can be shown was done to one side by the other. It's called the case or controversy limitation, and it comes from Article 3, Section 3, or Section 2 rather, of the Constitution. Article 1 is what defines the legislative power. Article 2 of the Constitution is what defines the executive branch's power, and Article 3 is what defines the power of the courts, of the judicial branch. And Article 3, Section 2 says, quote, the judicial power shall extend to all cases, to controversies to which the United States shall be a party, to controversies between two or more states, between a state and citizen of another state, between citizens of different states, between citizens of the same state, and between a state or the citizens thereof and foreign state citizens or subjects. So it's saying the judicial branch can't just go around and ruling on any question. There has to be a case or controversy between those kinds of parties. And what it's really doing is it's defining when a federal court has jurisdiction as opposed to a state court. So if two citizens of the same state sue one another and there's no federal question, they're suing, say, for breach of contract, that'll go to a state court, not a federal court. But that clause has been interpreted by the Supreme Court over many, many decades to limit the Supreme Court's or any court, federal court's ability or power to rule only when there's an actual lawsuit between two parties. They're judges. They're not floating arbiters of what is permissible and not. The only thing courts are permitted to do in the United States is resolve an actual conflict between two parties where one has allegedly harmed the other, and then the court rules. Here from Cornell Law School, they have a legal information study site that is actually very good at explaining the way in which constitutional provisions have been interpreted. There you see the title, The Requirement of a Real Interest. Quote, almost inseparable from the requirements of adverse parties and substantial enough interest to confer standing is the requirement that a real issue be presented as contrasted with speculative, abstract, hypothetical, or moot issues. It has long been the court's, quote, considered practice not to decide abstract, hypothetical, or contingent questions. A party cannot maintain a suit, quote, for a mere declaration in the air. And it's quoting there a 1937 case, Aetna Life Insurance versus Haworth, which was written by Chief Justice Charles Evans Hughes. And it often is a very important document. Now, actually, that quote did not come from that case. From what Charles Evan Hughes decided in this 1937 case, when defining the limits on the judicial power, he said this, quote, a controversy in this sense, meaning the constitutional sense, must be one that is appropriate for judicial determination. A justiciable controversy is thus distinguished from a difference or dispute of a hypothetical character from one that is academic or moot. The controversy, in order for courts to decide, must be definitive and concrete, touching the legal relationship of parties having adverse legal interest. It must be a real and substantial controversy, admitting of specific relief through a decree of a conclusive character, as distinguished from an opinion advising what the law would be upon a hypothetical state of fact. So what they're saying is, if you see your government enacting law that you don't like or that you believe is illegal, you can't just run to a court and ask a court to just kind of issue an advisory opinion on whether what the government did is legal. That's beyond the limits of a court's power under the Constitution. The only thing a court can do is see a case or controversy between a plaintiff and a defendant, or in criminal cases between the state and the defendant, and then rule based on an actual conflict between the two parties. And then they set precedent for how other cases like it are to be decided. So that's a real important limitation on the court's power. You don't want a court just being this floating arbiter of deciding legality. Now, here's what Amy Coney Barrett went on to argue as to why that kind of standing is lacking here. We showed that already. So here's what she said, quote, "Following a grant of panel rehearing, the Fifth Circuit affirmed in part and reversed in part the district court's ruling. It first held that the individual plaintiffs had Article III standing to seek injunctive relief, reasoning that the social media companies had suppressed the plaintiff's speech in the past and were likely to do so again in the future, and that both of these injuries were, quote, traceable to government coerced enforcement of the platform's policy and, quote, redressable by an injunction against government officials." It went on. The court also concluded, the lower court, the appellate court also concluded that the states had standing, both because the platforms had restricted the post of individual state officials and because the states have the, quote, right to listen to their citizens on social media. And then here's what Amy Coney Barrett said that a lot of media accounts deliberately ignored. A lot of media articles tried to pretend that this was a huge victory for the Biden administration because the court ruled that they weren't really censoring. The court refused to rule on that question. And as Amy Coney Barrett here says in this next passage, she said, "We begin and end with the question of standing." Meaning, once we find that the plaintiffs have no standing to bring this lawsuit, that's the end of the case. We cannot go on and then decide whether or not what the Biden administration did here is constitutional. And because they found no standing, they did not, in fact, reach the merits of the case. She says, quote, "At this stage, neither the individual nor the state plaintiffs have established standing to seek an injunction against any defendant. We therefore lack jurisdiction to reach the merits of the dispute. A proper case or controversy," that was the Article III limitation I just told you about, "exists only when at least one plaintiff, quote, establishes that she has standing to sue," quoting a Supreme Court case from 2019. "She must show that she has suffered," and this is Amy Coney Barrett not using he as a generic pronoun, but she, just referring to a plaintiff, quote, "She must show that she has suffered or will suffer an injury that is, quote, concrete, particularized, and actual or imminent, fairly traceable to the challenged action and redressable by a favorable ruling." And she's quoting there the case of James Clapper versus Amnesty International, which is one of those war on terror cases where Amnesty International sued James Clapper, arguing that his actions in the war on terror were unconstitutional, and the Supreme Court sidestepped that question as well by concluding that neither Amnesty nor the American citizens suing James Clapper could prove that they were actually harmed by the program James Clapper was implementing and overseeing, which I believe was the domestic spying program in this case, and we'll show you that in just a minute. This is how the court so often avoids ruling on these questions. And so the Supreme Court is citing that precedent where they protected the Obama administration and James Clapper from a ruling on whether their domestic spying without warrants was not constitutional. The court goes on, quote, "These requirements help ensure that the plaintiff has, quote, such a personal stake in the outcome of the controversy as to warrant invocation of federal court jurisdiction." Quote, "The plaintiffs, without any concrete link between their injuries and the defendant's conduct, asked us to conduct a review of the years-long communications between dozens of federal officials across different agencies with different social media platforms about different topics. This court standing doctrine prevents us from, quote, exercising such general legal oversight of the other branches of government. We therefore reverse the judgment of the Fifth Circuit and remand the case for further proceedings consistent with this opinion. So I just want to be very clear that this court, contrary to what a lot of sort of liberal pundits and corporate media outlets were trying to imply, while knowing it wasn't true, this court did not rule in favor of the Biden administration in the sense that they said they did nothing wrong, or that their pressure and coercion of big tech platforms was not unconstitutional. They didn't rule on those questions. They simply said the plaintiffs did not offer enough evidence to prove that they were directly harmed by the government's actions, that was the reason they were being censored. The court reasoned, look, Facebook, Google, Twitter, TikTok, they censor all the time on their own. And while it probably is the case, or seems likely, that the people suing here were censored because of government pressure, because they had evidence that the Biden administration was saying, you have to censor exactly the sort of opinions that these specific medical experts were expressing. And then Facebook, right after that call, would then go and remove a post or ban the person, even though it's likely, said the majority opinion, the individuals could not prove that it was the government that caused their censorship. Maybe it was just big tech acting on their own, even though at the very time they did it, they were being harangued and cajoled by the Biden administration. And they also said the majority couldn't prove that they were likely to be censored that way in the future, and therefore could not ask for an injunction. Maybe they can ask for other sorts of remedies, but not an injunction. Injunction is only when an unconstitutional or illegal act is likely to occur in the future, and then that way you can enjoin the party from continuing in it. So it's an incredibly stretched and dubious and just facially light attempt to avoid reaching a ruling at all. And this is what we told you after we heard the oral argument we thought was likely to happen, what the Supreme Court was likely to do. Just refuse on standing grounds to even consider this, and as a result, allow the censorship regime that the lower court said was among the gravest assaults on the First Amendment in the history of the courts that they've seen, allow that censorship regime to continue. Now, the dissent was written, as I said, by Justice Alito. He was joined by Clarence Thomas and Justice Gorsuch. And the dissent was very powerful in explaining why the majority's ruling was not only utterly wrong on the legal issues, but also incredibly dangerous in its outcome. So I just want to read you some of this so you understand what the implications of this is. Now, here's Alito's dissent, quote, if the lower court's assessment of the voluminous record is correct, this is one of the most important free speech cases to reach this court in years. Meaning this is not just a regular claim that the government violated the Constitution. He used the exact language that both lower courts used, that this is one of the gravest assaults on free speech in years. And then he went on to explain why. Quote, our country's response to the COVID-19 pandemic was and remains a matter of enormous medical, social, political, geopolitical, and economic importance. And our dedication to a free marketplace of ideas demands that dissenting views on such matter be allowed. I assume that a fair portion of what social media users had to say about COVID-19 and the pandemic was of little lasting value. Some was undoubtedly untrue or misleading, and some may have been downright dangerous. But we also know that valuable speech was also suppressed. Of course, purely private entities like newspapers are not subject to the First Amendment, and as a result, they may publish or decline to publish whatever they wish. But government officials may not coerce private entities to censor speech. See the National Rifle Association of America versus Vula. Now, let me just note what this case is and why it's so interesting that Justice Alito is citing it. The administration of Andrew Cuomo, when he was governor of New York, attempted in multiple ways to try to destroy the NRA because obviously the Democratic governor of New York dislikes to put it mildly, the ideology and political agenda of the NRA. And so the government, Andrew Cuomo, was threatening all sorts of private actors that you will be punished if you have anything to do with the NRA. And this conduct was so extreme that it was the ACLU that agreed to represent the NRA. The ACLU represented the NRA in this case because the ACLU believed that Andrew Cuomo's conduct against the NRA was so obviously an attack on free speech, even though the government wasn't directly censoring the NRA or they were trying to pressure private actors to destroy the NRA, that the ACLU felt they needed to defend the NRA, and the ACLU won. The court ruled in this case that Justice Alito was referencing that Andrew Cuomo acted illegally, not because he censored the NRA, but because as he used his government power, the Cuomo administration did, to threaten and coerce private actors to do that censorship for them, which is exactly what happened here. The Biden administration didn't censor anybody. They told big tech companies, if you don't censor the dissent that we want censored, there are a lot of ways that we're going to punish you. And as we said before, there's a long history of the court ruling on this, including in the Bantam Books case in 1964, when a bookstore was showing books that Rhode Island officials disliked, they believed was obscene, and they knew they couldn't order it taken down. So what they did instead was they started harassing and threatening the bookstore to take the books down. And when the bookstore did, the publisher of that book, of those books, sued, and the Supreme Court said, look, this isn't a case where the government censored the books itself, but what they did was they recruited private actors to censor for them. And the First Amendment not only bars the government from censoring directly, it also bars the government from pressuring or coercing private actors to censor for them. I've been writing about that line of cases for years to say the government's conduct in threatening big tech companies. You would see all the time the Democratic House summoning the CEOs of these big tech platforms and saying, if you don't censor more, we're going to punish you. We're going to undo the Section 230 protections that you have under the law. We're going to unleash our regulators on you. And it was so obvious that the government in the open was threatening big tech to censor the material that Democratic Party officials wanted censored. And I've been talking about that Bantam case and this line of cases for years. The dissent goes on, quote, the record before us is vast. It contains evidence of communications between many different government actors and a variety of internet platforms, as well as evidence regarding the effects of those interactions on the 7 different plaintiffs. For many months in 2021 and 2022, a coterie of officials at the highest level of the federal government continuously harried and implicitly threatened Facebook with potentially crippling consequences if it did not comply with their wishes about the suppression of certain COVID-19 related speech. Not surprisingly, Facebook repeatedly yielded. And remember, Mark Zuckerberg afterwards said that not only was the government constantly forcing Facebook to remove dissent about COVID, he said a lot of what we were forced to remove was either very debatable or in some cases it turned out to be true. The Biden administration forced Facebook, according to Mark Zuckerberg, to censor and remove dissent about the government's COVID policies and pronouncements that turned out to be true. Even if it weren't true, it would be an attack on the First Amendment. You're allowed as an American citizen to express opinions that end up to be false. But in this case, they were censoring true dissent. Alito goes on, quote, these past and threatened future injuries were caused by and are traceable to censorship that the officials coerced. And the injunctive relief sought by one of these plaintiffs was an available and suitable remedy. The evidence was more than sufficient to establish Hines standing. That was one of the plaintiffs to sue, and consequently, we are obligated to tackle the free speech issues that the case presents. The court, however, shirks that duty and thus permits the successful campaign of coercion, in this case, to stand as an attractive model for future officials who want to control what the people say, hear, and think. These demands were coupled with, quote, thinly veiled threats of legal consequences. And they cited the Bantam Books case from 1964 that I just described, using that language, that what the Supreme Court said in Bantam Books in 1964 about Rhode Island officials was that when the Rhode Island officials were telling the bookstore to remove these books, it was accompanied by, quote, thinly veiled threats, which means that it's proof that the government was coercing the bookstore to take down these books, not just merely asking politely. He then goes on, quote, 3 instances stand out. Early on, when the White House first expressed skepticism that Facebook was effectively combating misinformation, Slavitt informed the platform, that's a Biden White House official, a health official, that the White House was, quote, considering our options on what to do about it. In other words, if Facebook did not, quote, solve its, quote, misinformation problem, the White House might unseat its potent authority. The threat was made more explicit in May, when White House Press Secretary Jen Psaki parroted requests for platforms to, quote, stop amplifying untrustworthy content with, quote, a reminder that President Biden supports a robust antitrust program. Immediately after noting President Biden's support for antitrust enforcement, Psaki added, quote, so his view, Biden's view, is that there's more that needs to be done to ensure that this type of life-threatening information is not going out to the American public. The natural interpretation is that the White House might retaliate if the platforms allowed free speech, not if they suppressed it. Finally, in July, the White House asserted that the platforms, quote, should be held accountable for publishing misinformation. The totality of this record, constant haranguing, dozens of demands for compliance, and references to potential consequences evince, quote, a scheme of state censorship. Again, quoting Bantam Books. And then Alito went on to say that the outcome of this case will be that not just the Biden administration, but future governments are now free to constantly harangue big tech to censor dissent because they know that the Supreme Court has said how difficult it is for a plaintiff, even one who can prove they're censored because of the government's actions, to be able to have standing to bring a lawsuit. Now, I've been writing about this for many years, the way the Supreme Court abuses the standing doctrine, which, again, I believe is an important doctrine. It's a crucial limitation on the court's power. You need limitations on the power of all 3 branches, including the judiciary. But they did this constantly throughout the war on terror with refusing to rule on the constitutionality of blatantly unconstitutional programs, including in this case that Judge Barrett and the majority cited to justify what they did this week. Here from Reuters in February of 2013, quote, Supreme Court throws out a challenge to surveillance law. Quote, U.S.-based journalists, lawyers, and human rights groups cannot challenge a federal law that allows surveillance of some international communications, the Supreme Court ruled on Tuesday, in a case touching on government efforts to fight terrorism. Split 5-4 on ideological lines, with conservatives that time backing the government and the liberal wing in the minority. The country's highest court said none of these categories, including human rights groups like Amnesty International and Human Rights Watch, have legal standing to sue because they could not show they had suffered any injury. The law in question that they were challenging was the 2008 amendments to the FISA Surveillance Act that authorized mass surveillance by the U.S. government without identifying specific targets for the purpose of monitoring foreigners outside the country and gathering intelligence. And the argument was it also allowed the Supreme Court, when targeting foreigners, to also listen in on the conversation of American citizens, talking to them with no warrants. And just in a sign of how malleable the law is, the justice who wrote the majority in that opinion, finding that plaintiffs had no standing to challenge the government's domestic surveillance activities, was Justice Alito. the same justice who wrote the dissenting opinion arguing that standing had to be conferred, in this case, against the Biden administration. Now, this was a case against the Obama administration, saying that the Obama administration was illegally spying. Quote, in Tuesday's ruling, Justice Samuel Alito wrote on behalf of the majority that the challenger's arguments was based on, quote, a highly speculative fear that the government would target their communications and not choose other means to carry out surveillance if it was required. The law states that U.S.-based people should not be targeted, and the various individuals and groups that filed suit have not shown any evidence that they have been, Alito said. Likewise, the law's opponents had no evidence that the non-U.S. people they were communicating with had been targeted either, he added. Quote, we decline to abandon our usual reluctance to endorse standing theories that rest on speculation about the decisions of independent actors. So there, the government was spying without warrants on the conversation of certain American citizens. When groups would sue to get the list of the American citizens they were spying on with no warrants, the courts would say, oh, we can't order the government to disclose that because forcing them to disclose that list would endanger national security. And then when groups that had a lot of reason to believe that their conversations were subject to warrantless surveillance sued to get a ruling that the Obama administration's domestic spying program was unconstitutional, the courts would turn around and say, sorry, you can't prove that you're being spied on because the list of targets that they're spying on, we allowed them to keep secret. And because it's secret, you can't prove that you were targeted, and therefore, because you can't prove that you were targeted, you have no standing to sue and get a court ruling on the constitutionality of that warrantless surveillance. This is how the court for 2 decades now has been taking a very legitimate doctrine, the doctrine of standing and only ruling on a case or controversy, and widening that requirement to such an extent that they're almost making it impossible for American citizens to challenge the actions of the executive branch by arguing that the executive branch's actions violate core constitutional rights, because the doctrine of standing has been expanded to such an extent in 2013 with respect to domestic warrantless spying, in 2024 with respect to a censorship regime resulting in the censorship of American citizens on the internet, that it's essentially shielding the executive branch and allowing it to engage in unconstitutional behavior by making it harder and harder for anyone to sue and get a ruling in this regard. And as a result, a censorship regime that the lower court, that the unanimous appellate court, and all 3 dissenting judges of the Supreme Court have all said is one of the gravest assaults on free speech in history, is now allowed to continue, not because the court ruled that it's constitutionally permissible, but because the court simply refused to hear the case at all. Thanks for watching this clip from System Update, our live show that airs every Monday through Friday at 7 p.m. Eastern, exclusively on Rumble. You can catch the full nightly shows live or view the backlog of episodes for free on our Rumble page. You can also find full episodes the morning after they air across all major podcasting platforms, including Spotify and Apple. All the information you need is linked below. We hope to see you there.